Okay. All right. Please sign into the attendance when you can. Okay. All right. We get started? Okay. All right. Sign into the attendance when you can. I have it running. I think. All right. Lindsay, were you able to watch the video from last week?
Yes.
Okay. And were you able to watch the video okay from last week?
Sure.
Okay, very good. Have fun in Vegas? Don't tell. It's not important. It's actually better not to.
I was with you guys for a little bit. I couldn't tell there was only 2 in class though.
Yeah, it was just Audrey and Chelsea, right? It's fun. It was like every other case. You had 2 cases, and every other case was on call. All right. We are moving along quite well. In our last class, we talked about equal protection with respect to the school segregation cases, Brown v. Board, Bowling v. Sharp, and then we discussed the aftermath of those with respect to Cooper v. Aaron and the resistance, as well as Loving versus Virginia and the anti-miscegenation laws. Randy says miscagination. I don't know why he says it, but anyway, I don't want to correct him. He says miscagination. That's how he says it. One of our people made a comment saying it's, anyway, I say miscegenation. I don't pronounce the C. Okay, so we have different cases, right? In Brown, the school district was using race as a means to discriminate, right? They were trying to exclude people based on using racial classifications. The cases today are a little bit different. Rather than using race and racial classifications as a means to exclude racial minorities, here the government is using racial classifications as a means to include racial minorities. So you see the sort of split, right? In Brown, you're using race to exclude, and in the affirmative action cases, you're using race to include. Although I suppose that depends who's asking, right? If you're Alan Bakke and you're a white student, you would argue, no, this is not including me, it's excluding me. And this is the sort of controversy of affirmative action that's never gone away. This is an issue that's been in the news for almost, 50 years. And the issues that Justice Powell confronted in Bakke in 1977 are still live and with us, 40, 50 years later. Right? So these issues never seem to go away. And to be frank, I don't know that the Fisher 2 case resolved much. Now that the court has taken a little bit more of a conservative turn, I can see the next affirmative action case going a little bit differently. All right, so any general questions? Okay. So let's take a step back and look at this more holistically, right? The 14th Amendment has an equal protection clause, which we've read now several times. It doesn't really say that the government cannot classify people on the basis of race. Indeed, in earlier decisions, for example, like Plessy, the court held expressly that the government can classify people on the basis of race. They can have a train car for white people and a train car for black people. But following Brown, a general sense developed. And you even saw some Korematsu. It's the idea that when the government classifies people on the basis of race, they better have a really, real good reason why they're doing this, right? To classify people based on race, it became known as a suspect classification. The word suspect is like suspicious, right? The courts are suspicious when the government tries to treat people differently based on their race. Now, why are courts suspicious with racial classifications? The answer has largely to do with our history, right? when a person is being judged not who they are, but based on the circumstances of their birth, quite literally, their skin color, we generally presume that their skin color doesn't inform who they are, and that the government is acting not based on some sort of rational basis, but based on some sort of impermissible justification. That is racism. Right? Even think of Korematsu. Justice Black wrote that the Japanese classification at issue was immediately suspect. But the court upheld the racial classification in Korematsu because the state had a really good reason. It found national security was a justification. Right? That the only way to preserve the West Coast from foreign attack was to have this sort of blanket ban that applied to all Japanese Americans. Right? And what other cases have we done? We've done Brown, right, where the court says that there's very bad consequences to having segregated racial education. Then we did Loving, where the court said that, trying to safeguard children from the harmful effects of interracial marriage is not a good enough justification for a racial classification. Okay? So the question becomes, if the government wants to classify people based on race, it's not automatically forbidden. Rather, the government needs to show that they have a really good reason for doing so. Right? What's the reason for doing so? Right? How are you using race? So it's a myth to say the government can't consider race. They can. But they can only do so when race is considered in a narrow fashion. Right? When race is considered in a very limited way to achieve something that's very important or very compelling. Right? And that's the basic framework for what's known as strict scrutiny. Right? If they want to make a classification on the basis of race, they have to use race in as little of a way as possible. And they have to do so to achieve a really important, a really compelling governmental interest. If they use race in a sloppy way that, it's not very precise, they can't do it. If they're trying to use race to achieve an interest that isn't really that important, they can't do it. So what we're left with is the question, why are the government using race, or why is the government considering race, and how are they using it? And those are the questions we have to ask ourselves. In the affirmative action case, I assigned 4 or 5 cases, and basically they all say the same thing, right? They don't go much beyond what Justice Powell wrote about, in the 70s, right? They're all basically saying the same thing. And you can see how divided the court is over this issue. Now, why are they divided? I'll jump ahead a little bit. Justice Thomas talks about this, but I want to get to it first. There are 2 major conceptions of how the court can consider race. One might be the so-called Justice Harlan approach, right, from Plessy. And you recall that Justice Harlan said that the Constitution is colorblind, that it does not permit the government to consider a person's race when they're making decisions. Now, that has 2 consequences. 1, you can't segregate, like in Brown. 2, you can't use race to integrate. You can't use race as a means of higher education affirmative action policies. You can't use race for purposes of government contracting, right? And Justice Stevens had a memorable line. He said there's a difference between using race as a do not enter sign and using race as a welcome mat, right? Are you using race to keep people out, or are you using race to welcome people in? And that divide, I think, largely explains all of these cases, right? For those who uphold the affirmative action programs, these are ways to welcome in people who are excluded from our society otherwise. And those who vote these affirmative action policies are unlawful. view these as just an extension of racism. Indeed, Justice Thomas's dissent in the Texas case compares the government policy in UT to the segregationists in Brown. And he's very candid about his approach here. Even on the court today, you have these two different perspectives. Justice Sotomayor and Thomas both went to Yale Law School. I think they graduated within a couple years of each other. You can check me on it, but they were a couple years apart. And they both admitted that they were admitted, at least in part, because of affirmative action policy. But they have very different reactions to that policy. Justice Thomas long resented the fact that he was admitted because of affirmative action. He's written about this in his book, his biography called My Grandfather's Son, which I encourage you to read. And he's basically said that the fact that I got admitted through affirmative action cheapened my diploma. That when people see that I was admitted to Yale because of affirmative action, because of my race, they think that I didn't earn it. And that diminishes my accomplishment. And for the longest time, Justice Thomas wouldn't visit Yale. In fact, his diploma from Yale, he said he put a cigar sticker on it. That's how much he valued it, like 25 cents, whatever it was. He eventually came around and visited Yale. He's been there, so things have sort of quieted down. It took like 30 years. But he had a long hostility. And then you have, in contrast, Justice Sotomayor, and she wrote about this in her biography called My Beloved World, which you should also pick up a copy of. And she explains that were it not for the affirmative action policies at Yale, she would not be an attorney and she would not be a justice in the U.S. Supreme Court. So she's very proud of it. And it's amazing that two people, both from racial minorities, both who had very difficult upbringings in the world, can go through the exact same program, rise to the peak of their professions, both U.S. Supreme Court justices, and reach such opposite conclusions of life. And I think I use this anecdote as a way to explain that the justices are doing the best they can. They're approaching the law as best as they can. I don't think they're politicians. I really don't believe that. But their own philosophies informed by a life world experience can lead to very different opinions on the Constitution and very different opinions on what equal protection commands. And I don't think they're going to change each other's mind on this. They're probably all very good friends and they like each other, but they probably disagree strenuously on these matters. One other anecdote before I actually jump into Bakke. I assigned at the end of the chapter the Freedmen's Bureau Act, which it's a nice bookend for this topic because it illustrates that even at the time of Reconstruction, those who framed the 14th Amendment enacted legislation that would have given specific benefits to the freedmen, that is, the freed slaves, right? And granted, these were not racial classifications, right? They didn't say we will give all these benefits to people because they're African American. No. Well, the only people who were freed slaves were black people. That's it, right? To be a freedman meant you were of African descent. So you had the framers of the 14th Amendment giving express benefits to these people. Now, Justice Thomas has never addressed this fact. It's something I've groused about over the years. He can cite Justice Harlan and cite to the need for a colorblind constitution. But he's never reconciled with the fact that those who framed the 14th Amendment, the Freedmen's Bureau Act, right, were eager to provide benefits on the basis of race to the freedmen. Now, perhaps the answer is that those racial benefits were essential in the 1870s and 1860s to bring the freedmen into the fold, and maybe these sorts of affirmative action benefits are no longer essential. Justice O'Connor, we're at 25 years, we're counting down. I think we're at 2003, I think we're at almost 16 or 17 years now, if my math is right. So maybe the answer is those benefits may have been justified at the time, but they're no longer justified. Maybe that's the answer. But Justice Thomas has never quite reconciled with that history. It's disappointing me. I was hoping he would do that with the Fishers, and he hasn't. We'll see what next Okay, he's up next. Why don't you raise that hand?
Yes. What were the two approaches? Is the Harlan approach, which is kind of like Thomas's.
Colorblind, yeah.
And then the second one.
It's sort of the no trespassing versus welcome mat sign. And that was Justice Stevens. Yeah, he's not very important, but he articulated that in an opinion called Adirondack versus Pena in the mid-90s. But you know, Sotomayor, I think, uses that perspective. I think Ginsburg in her Michigan case uses that perspective as well. We don't have the dissents in Bakke. I don't have them in your book. I sometimes wish I did, but there's not enough room. Justice Thurgood Marshall, right? Thurgood Marshall was the head of the NAACP Legal Defense Fund, right? He argued Loving, right, for the NAACP. Justice Thurgood Marshall wrote a dissent which basically said affirmative action is necessary to remedy the centuries, not decades, the centuries of segregation and subordination that were inflicted upon African Americans, right? President Johnson, LBJ, gave a famous speech at Howard University. I think it was a commencement address. And he basically gave this analogy. Imagine you're running a race, right? And you're about to start running, and then the person next to you has chains on, right? And you start running without the chains, and he's running with the chains. Eventually, he gets the chains off, but you have a head start. He described affirmative action as a way to give a head start to the person who basically had all those chains on for all those years. Now, that suggests that once that sort of social stigma has faded, the accommodations will no longer be necessary. This is sort of what O'Connor was getting at with her 25-year bit. But true devotees of affirmative action would dispute that and say that that sort of chain can never be eliminated, that it's there forever, or at least indefinitely, in which case the need for affirmative action is more or less indefinite. But none of this stuff actually matters because Justice Powell didn't accept that justification. Justice Powell didn't accept the idea that we can have affirmative action to compensate people for past discrimination, right? To give them an advantage where other people might have that. All we have is Justice Powell, which is the educational benefits of diversity, right? If I were to poll, 20 college students why affirmative action, I think 0 of them would say the benefits from diversity for educational. No one would say that. They think it's to make up for social inequality or something to that effect, and that's not the reason why. So we have this weird dance where schools have to editorialize a little bit. They have to make stuff up, right? They basically have to put forward a justification that's not real. We all know why they're doing it, but they have to do this sort of dance, like, we need a critical mass to have educational diversity. That's not the real reason. They want to make up for social inequity. It's very obvious. And they have to do this dance because of Justice Powell and Justice O'Connor. Yeah, that's where we are with affirmative action cases. And not much has actually changed since Justice Powell. We're basically in the same spot. Okay. Questions on, excuse me, talking too much, on that sort of general gestalt? All right. I didn't mean to rant at the end, but it's true. This came up in the Texas litigation when I think, was it Alito or Roberts asked the lawyer for the Texas university, what is a critical mass, right? How do you know when you're going to get there, right? How many students is it? And, of course the lawyer can't answer the question. Why? Because the second he answers the question what a critical mass is, like, you have a quota, right? It's a sort of double-edged trap that you need to have a certain number of minority students, but you can't give that number because that's a quota, and the court in Bakke said you can't have that. So it's this bizarre dance where they say, we need a critical mass, we can't tell you that is, but we'll know when we see it. I would much rather have the candor of just admitting what they were doing, but the canons of current law. There's still litigation about this now. There's suits against UT. There's suits against the University of North Carolina. The suit against Harvard. The suit against Harvard is different. The Harvard suit argues that they're discriminating against Asian students, that basically the school has put on such a negative burden on Asian students that they're actually excluding them. It's not about including, it's excluding Asian kids. And that case is moving forward, and I get to the court in another 2 years or so. But that case is proceeding at pace. All right, anything else? All right, Lindsay, you want to start us off with Bakke, please?
Sure. So, Alan Bakke was a white man who had applied to the University of California Medical School.
Mm-hmm. At Davis, yeah.
At Davis. And
right outside of Sacramento.
And was rejected. The school had an entry class of 100, and 16 of those places were reserved for minorities as part of the university's affirmative action program.
Very good.
So he argued that it violated the Title VI of the Civil Rights Act of 1964 and the Equal Protection.
Okay, let me just pause you there for a minute. Title VI is part of the same law that you studied in Heart of Atlanta Motel and Katzenbach, right? In 1964, Congress enacted this legislation that prohibited segregation in lots of contexts, right? Title II of the Civil Rights Act concerned places of public accommodation, right? That's why the restaurant and the hotel had to get rid of their discriminatory policies. You've probably heard of Title VII. This is an employment, oh, you're HR, right? Yeah, Title VII was the employment context where you couldn't discriminate in the context of employment, right? You can't hire or fire a person, for example, because of their race. Title VI is different. Oh, you've heard of, Title VI is different. Title IX came later, I'm sorry, but you've heard of Title IX also. Title VI is different. Title VI basically says that if you are a school that accepts federal funding, which is basically all of them, you cannot discriminate on the basis of race. Now, I think I said in class last week that what really broke up segregated schools was not the Supreme Court, it was actually the federal government. And one of the means was Title VI, that the feds would now withhold money from segregation in schools, and eventually the schools came around. Did you ask your mom about the council schools?
Uh-huh.
Did you show her that picture from Wikipedia?
Yeah, I sent her everything.
What'd she say?
Because my family was in a group chat, and
Oh, that's
they
so
were,
cute.
like, amazed. They had no idea.
They had no idea.
Yeah.
Oh man.
So.
Did she feel like weird or no?
Yeah, but then we listened to the video, and you can like barely hear me, so it's okay.
Yeah, no, you're fine.
Don't worry. But
No, you're fine. Students are inaudible.
Yeah, no, they were kind of laughing about it because we don't talk to my grandma anymore. So.
Okay.
She had no idea.
Okay, very good. All right, so Title VI was enacted in '64, and it says you cannot discriminate on the basis of race with respect to higher education or any sort of educational school. Okay, fine. Title VI is not the Equal Protection Clause, and I'm mentioning Title VI because this is actually the basis of the Harvard lawsuit, right? Harvard is not a state institution. How can you sue Harvard for excluding Asian students? The answer is Title VI. And what the courts have held, I think I'm right about this, is that the standard for the Equal Protection Clause is the same as the standard for Title VI. So if you're violating the Equal Protection Clause, you're also violating Title VI. So effectively, whatever standard applies to state schools also applies to schools that accept federal money. And again, all schools accept federal money, right? All of your student loans, that's federal money. So the litigation in Harvard is actually based on Title VI. Okay. We have claims under Title VI, and we have claims under the Equal Protection Clause. Right, Audrey, walk me through the votes in Bakke, because the votes in Bakke are complicated.
Yeah, it's.
Take your time. It's not easy. This is one of the harder splits you'll have in this semester. I know.
I guess for the votes as in the justices.
Yeah. So walk me through the votes.
It was basically 4, and then 5 in the middle, and Powell's the one in the middle.
Yeah.
But
So Yeah, this diagram is actually a little bit helpful.
Yeah, before they said affirmative action doesn't violate the 14th Amendment or Title VI.
Okay, very good.
Other ones said that the admission policy violated just Title VI, so you didn't even have to go the constitutional question route. They just kind of went straight to Title VI.
Okay, very good. So a few things to help explain this holding, right? First, Justice Powell was the moderate, was the swing vote of his generation. The same way that Justice Kennedy was for many years, Justice Powell was a swing vote. And in this opinion, he sort of reached this middle-of-the-road position, right? That left things very unsettled. So first off, you had the four conservatives. And I even hasten to call Justice Stevens conservative, but he at the time was somewhat more conservative than he became. So you had Berger, Potter Stewart, William Rehnquist, and John Paul Stevens. And they voted that the policy violated Title VI. Now, because they ruled it violated the statute, there was no reason for them to decide whether it violated the Constitution. Right? Generally, if you think something violates the statute, you don't treat it as a constitutional question. But then you had the four liberals. You had Justice Brennan, you had Justice White, you had Justice Thurgood Marshall, and Justice Harry Blackmun. No relation, spelled differently. And they ruled that the policy was both constitutional and the policy was consistent with Title VI. That left Justice Powell in the middle. He cast the deciding vote. Now, this is a weird attribute of the Supreme Court. How can it be that the majority opinion, the controlling opinion, was the position reached by one person? When you have four on one side and four on the other and one guy in the middle, how is it that the one dude is a controlling opinion? This is one of the quirks of the Supreme Court. This is the rule. When there's no majority, that there's no five-member majority, the most narrow opinion is controlling. Right? This is really in the weeds. But when you have no majority opinion, the most narrow decision is controlling. And here, Powell had the most narrow opinion, where he argued that the policy was unconstitutional, but he didn't really decide the Title VI issue. Right? So he was somewhere in the middle. And even Powell, it wasn't clear, was controlling, but in years later we would see in the Michigan case that Powell did control. So this is one of these weird aspects where the Supreme Court was very fractured and they couldn't agree on something. Right? Had Powell agreed with the conservatives that Title VI was violated, then the case would be over. Right? But Powell went ahead and reached the constitutional question. And he left sort of things in the open, in the air. So there was not a single 5-vote block for any position in this case. So once again, Powell was the kingmaker. So you have 8 justices who disagreed with Powell. Right? He was the only one who found unconstitutionality, but his opinion controlled. So it's a very strange quirk of Supreme Court math, where somehow 1 is greater than 8. Yeah, it's weird.
Powell normally go.
He went both ways. He was like Kennedy. He would often flip left to right. He was a swing vote for the day. For about, I guess he was appointed in 72 and he retired in 87. You can check me on that. But for about a decade and a half, he was a swing vote. Justice Stewart often was a swing vote as well. Justice White would often swing. There were Stewart, Powell, and White would often kind of go back and forth in these sorts of cases. They were the more moderates of the day. Berger and Rehnquist were pretty conservative, and Brennan and Marshall were to the left of Stalin. I'm sorry, but they were quite liberal. Blackmun as well became more liberal later in his career. Initially, he was a little conservative. He eventually relented. Okay, so any questions on the split? We'll get to actually what Powell said. But everyone get the split? Okay. All right, Tyler, you want to walk me through the Powell opinion? How does he approach this issue?
That he lays out initially, I mean, that anything that concerns race is inherently suspect.
Good.
And must be subject to the most strict scrutiny.
Very good.
You know, and then further than that, that when it is supporting or purporting to support a not legitimate nor substantial but compelling state's interest, that it could be put to use. So it's not that Davis's idea or intent was wrong; it was their implementation that was incorrect.
Okay, so what was the big no-no? What did Davis do that ran afoul of the 14th Amendment?
There's 16-person block set aside specifically for minority students, minority races, was exclusive of the white individuals like Baki. So it wasn't a factor; it was the factor.
There we go. Okay, so this is the framework that Justice Powell sketches. He explains that race can be used as one of many factors, but race cannot be used as the sole defining factor. At Davis, 16 of the 100 seats were set aside specifically for minority applicants. As a white applicant was not even eligible, he could not even enter that door, could not even consider that seat. As a result, he found that race was being used in too broad of a fashion. Okay. But that's only half of the opinion, right? Lindsay, why did Justice Powell think race could be used? What state interest was affirmative action pursuing, accomplishing?
He said that the state had a compelling interest of a diverse student body that would benefit the education of the students.
Well said. In your own words, what does that mean?
That if you have a diverse student body, that it benefits all the students and the school.
In what regard?
Towards education.
How? Let's say, Audrey, you're next. I can hear.
Yeah, I guess because you can learn from different backgrounds.
That's the thinking, right? The thinking is this, that if you are only exposed to people who look like you, the range of experiences you'll learn about are narrow. If you have a certain amount of racial diversity in the classroom, the odds are you will also be exposed to different worldviews. Now, this presumes that people of different races will, by necessity, convey different worldviews. And this actually came up in the Texas litigation, where one of the lawyers, I think for UT, said that we're not only interested in having, poor minorities, but we also want, how do you phrase it, the rich African American students from a Dallas suburb, right? That they wanted different types of racial minorities. So the race by itself is enough, but that they're trying to achieve different strata of racial minorities to promote some sort of educational benefits. Exactly what this means has been debated about for decades. But the rule from Powell and the rule in DeGrooter for Michigan is this: the school can obtain diversity as a means to promote the educational benefits that flow from that diversity. Race cannot be used to remedy past injustice in higher education. Right? The reason which I think most people polled would agree, remedying injustice in the past and the present, that doesn't cut it. And the solo concurring opinion has to this day proved what the rule is. And again, Powell was from Virginia. Virginia was a segregationist state. He had firsthand experience in racial segregation from his younger days. And this is the opinion of the court. Now, Powell also praised the Harvard program. This is important. The Harvard program, which was a private college subject to Title VI, the Harvard policy used race as one of many factors. Exactly how is not clear. It doesn't even matter to him. But the second that Justice Powell said the Harvard one's okay, he basically gave a green light that if a school wanted to use affirmative action, they would just copy whatever Harvard did. And that gave a sanction, an approval to how the other schools would go forward. And indeed, most schools simply just said, oh, we're doing the Harvard plan, right? That's what we're going to do. And that's what they went forward. Okay. Any questions on Mr. Alan Bakke?
Yes, sir.
Yes, go ahead.
The two classes, were they, when he talked about two-class theory, was that nationality versus race, or just what is the majority now and the minority?
All right, so this is an important point. Let me just mention this. Justice Powell talks about this sort of two-class system, right? And this sort of speaks to Justice Thomas's concern, right? That there are going to be some people who are admitted under the normal track, right? The normal admissions policy. And other people, other minority students, will be admitted under the other track where the criteria are easier to get into. And they may be viewed as inferior. What Powell is trying to avoid, I think O'Connor the same, is the impression that someone admitted who's a racial minority was admitted because of their race, to prevent this sort of two-track, this two-class, this two-tier, whatever you want to call it, system of insubordination, that basically you're only here because of your race, which in itself reinforces inequality, right? That if someone understands a person's there solely because of their race, that person will not even get the benefits of their diploma. This is what Clarence Thomas put a cigar sticker for 25 cents on his diploma, because he said, oh, you look at this, I'm just here because I'm black. Right? And I think that's what O'Connor and Powell are trying to avoid. They're saying, no, you're here because you belong here, but race can be as part of the admission process. Exactly how that works is left to the universities in large part, at least until Fisher, I think, Fisher 1 at least. But the universities can figure out how to work that out. Does that make sense?
It does.
Okay. What is this thing to hang up? I don't even know what this thing is. Whatever. Okay. Questions then on Bakke. And here's Alan Bakke graduating from med school. Okay. All right. Next case is, so the Michigan cases. These were decided when I was in college. I think 2003. Yeah, I guess I was just finishing my freshman year. I remember reading about this like in the USA Today. I was like, look at that. I didn't really think about it much. And I think I had a professor at the time who said something like, even if the Supreme Court rules that Penn State, which is where I went, can't use it, she said, we'll just find different ways of using race. She was pretty candid about this, which she was being completely honest. She was like, it doesn't really matter. We'll find different ways of using it. But okay, we have the Michigan cases. Now, let me give a little Texas flavor here. In the early 90s, UT, which was the premier college in the state, used basically the Harvard policy. It was challenged in the Fifth Circuit, and the Fifth Circuit ruled that UT's policy was unconstitutional. For one reason or another, I can't remember why, the Supreme Court didn't review the case. I can't remember exactly why. I remember Ginsburg wrote a dissent or something, but the Supreme Court didn't review that decision. So at least in Louisiana, Mississippi, and Texas, for some time, affirmative action was prohibited. During that period, Texas developed the so-called 10% plan, which is not actually even 10% anymore. Was it 5% or something like that?
It was 10%.
It was at one point, but now it's lower.
It was like right before I was at college.
The gist is this, that if you are in the top 10% of your graduating high school class, you're guaranteed admission to one of the UTs, either UT or A&M or I think Texas Tech, right? Now, on its face, it looks race neutral, but it's de facto segregation because virtually in most high schools in Texas, it's a predominantly white high school, a predominantly black high school, or a predominantly Hispanic high school. There are not many fully integrated high schools, just as a factual matter. So it was drawn expressly to consider race, even though on its face it was race neutral. Texas kept the top 10% plan until Grutter. When Grutter was decided, they reverted to affirmative action plus top 10%. They used both, right? So for some time, Texas only had the top 10%, and then after Grutter, they had top 10% plus the affirmative action policy. And we'll read later, Fisher upheld the Texas policy. But Grutter was an important point because it actually blessed the sort of Harvard plan that the Fifth Circuit said you can't have. Okay, so let's do Grutter and Gratz. Grutter concerned the University of Michigan's undergraduate policy. I'm sorry, yeah. Grutter was the University of Michigan's undergraduate policy. Damn it, I flipped. I'm sorry, I said it the right first time. Gratz versus Bollinger was the undergraduate, and Grutter was the law school. I'm sorry, I flipped it in my head. This is one of these weird cases where Justice O'Connor quite literally cast a deciding vote. In Gratz, she voted with the majority to declare unconstitutional the undergraduate policy. And the very same day, she wrote her own majority opinion to declare the law school policy constitutional. The challenge for law students, for generations it seems, is trying to figure out why did O'Connor vote to set aside the undergraduate policy on the same day that she upheld the law school's policy. Right? Who's next? Lindsay, Audrey, or Tyler? I think you're next, right?
Yes, sir.
All right. So first, Tyler, walk me through Gratz, the undergraduate case. Why did the court find that the undergraduate policy was unconstitutional?
It didn't allow the same type of individual review. Race was a factor, but it was a factor that included a guaranteed number of points in their sliding scale. So 20 points automatically if of a certain classification of race, without any individual consideration in that. It was purely mathematical at that point.
Very good. Thank you. The undergraduate program resembled the quota at issue in Bakke. It was a strict mathematical formula that if you were a member of an underrepresented minority group, you were added 20 points off the top. Right? In some regards, having a perfect SAT score, 1,600, was less valuable than being a member of a racially underrepresented group. By a 6-3 vote, with both Breyer and O'Connor in the majority, the court found that this policy was unconstitutional. Stevens, Souter, and Ginsburg dissented, and they basically took the welcome mat approach. They did not think that using race to help minorities was ever unconstitutional, that the state could always use race as a beneficial means. Justice Thomas vigorously disagrees. He argues that race can never be used as a helpful means. At any time the government considers race, they're denying these people their equality, right? Even if they're getting perhaps a short-term benefit, admission, in the long term they're treating them unfairly, and that should not be allowed. Okay, so any questions on Gratz, the undergraduate policy? All right, Lindsay, you want to walk me through Grutter, please, the law school one?
So in Grutter, she applied to the law school, and it was found to be constitutional because race was one of many factors that were taken into consideration, along with serious consideration was given to all other factors, and it was an individualized, holistic review of the applicant, meaning they took into account everything altogether instead of weighing one factor more strongly or than the other.
Mm-hmm.
And this is where she talks about the critical mass of underrepresented minorities,
Mm-hmm.
and that there should be no quota or two-track admission system.
Yeah, that was Tyler's
Okay.
question a few minutes ago, right? That you shouldn't have a system where someone's admitted under a different track if they're a racial minority. That they shouldn't think they were admitted solely because of that. The law school discussed this idea of a critical mass of racial diversity. That if you have this critical mass at this certain level of racial breakdowns in your school, at that point you get these benefits to education, and that the only way of achieving those benefits is through affirmative action policies. That if they don't use these policies, they can't get to that magic level of diversity. So what's our question, right? How are they using race, and what are they using race for? They say they're using it to achieve these benefits. They can't really tell us what those benefits are with any precision, but they do cite these benefits. Is the interest here compelling? The court says yes. The court says that the benefits here are compelling because of, or in light of Justice Powell's concurrence 30 or I guess 20-something years earlier at that point. Again, Justice Thomas dissents vigorously on this point. He argues that having an elite law school is not a compelling interest. Indeed, he argues the state has no interest in having a law school. He continues, most people go to the University of Michigan Law School, transfer out to other states. They don't even stay in the state, which I think is true to this day. So the state has no interest in having an elite law school. And if they want to have a more diverse class, what can they do? Lower their admission standards. And he gives the examples of historically black colleges that try to admit a higher concentration of minorities, and they don't maintain high SAT scores. Maybe the LSAT is a biased exam, then stop using it. In other words, Thomas argues this is not what compelling governmental interest means, right? Usually compelling interest means like national security or something of the highest order. But here, this is only he basically says it's a vanity issue, right? It's about aesthetics, about how people look. It's not about actually trying to improve the lives of minorities. I think the Grutter dissent from Thomas is full on display of his perspective of this sort of race issue. He's very vigorous on this point. Yeah, Audrey?
Question. I keep getting mixed up, I guess, in each case what the compelling state interest is. Is it like the purpose for?
Right. So let's talk about this for a minute, right? We talk about this sort of means and scrutiny, right? And we always ask, what is the government doing and why are they doing it, right? Here they're using a racial classification to promote educational diversity. Okay. So we say, what is the state interest here? It's the benefits from educational diversity. The government can only use race to achieve interests of the highest order, what's called a compelling state interest, right? They can't just use it to do any purpose, right? They can't use race because they think it'll be helpful or that it might be useful. It's got to be compelling, important. And Justice Thomas argues vigorously that whatever benefits can flow from education are not compelling. They're not even important. The state has no obligation to even keep a law school. They don't even. Some states don't even have one. Alaska doesn't have a law school, right? So this is not a compelling interest. Therefore, no matter how narrowly tailored the race is used, it's not going for the right cause. That makes sense? We'll do a little bit more on the sort of means and scrutiny tomorrow when we do the gender discrimination cases. It's a little bit easier to argue with gender. But as a general matter, the government should not use race. And if they're using race, they have to have a damn good reason. The majority thinks that the educational benefit from diversity is a good enough reason. Justice Thomas thinks it's not. That's not a compelling interest at all. Thomas also argues that having benign or helpful racial classifications only harm minorities. They do not help them. Okay. Only 2 of you left, so he's coming back. Any questions on Grutter or Gratz? Okay. So fast forward several years, right? We have changes in the composition of the court. Chief Justice Rehnquist is replaced by Chief Justice Roberts. Justice O'Connor, who was a swing vote in Grutter and Gratz, she is replaced by Justice Samuel Alito. And Justice Kennedy now becomes the deciding vote. Now, Kennedy had voted with the majority in Gratz and with the dissenters in Grutter. Right? Kennedy was with both of them. How would Justice Kennedy vote now? Well, there were a couple of cases decided in the 2000s that are relevant. One involved affirmative action in K through 12 education. The case is called Parents Involved. And the court basically held that the affirmative action policy in the lower schools was unconstitutional. 4 justices said it can never be used, and Kennedy sort of split the difference and said, well, maybe it can be. He never liked making a tough decision. He always was to be in the middle. And then we get to the University of Texas, right? We know Texas has a top 10% plan, which some of you may have used. But they also had an affirmative action policy, which was modeled after the Grutter approach, right, the law school approach. The UT policy was challenged, and they argued that it wasn't constitutional. Now, the plaintiffs in the Fisher case were not asking to overrule Grutter. This is an important point. They argue that even under Grutter, the school didn't establish enough of a framework of how they were using race. They were using race in too much of a way, right? So we have 2 cases, Fisher 1 and Fisher 2. Now, we know Fisher 2 ended, but when Fisher 1 happened, we didn't know what was going to go on. It's so, you're teaching these cases in hindsight, it's okay, this is a sort of neat package. But at the time, it was very uncertain what would happen. So let's start with Fisher 1. I think, Audrey, you're next. You want to walk me through Fisher 1, please?
So, Fisher, she was a white woman. She was denied admission to UT or University of Texas at Austin.
Good. Yeah, actually, I'll interrupt you briefly. She went to LSU instead, and she was apparently resentful. One of my students several years ago was actually a high school classmate of hers, and they said she was very weird, and she was very bitter because she went to Sugar Land High School, which is apparently a very good school, and she couldn't finish in the top 10% of her class because it was a very good school, and so she was bitter. She apparently works in Austin now. I think she works for Merrill or Goldman, one of the investment bankers, so she made it okay. One other footnote. There were actually 2 plaintiffs originally. It was Fisher and one other girl. The other girl dropped out of the case. Why? She went to SMU for law school. And I think she got advice, you do not want to be the named plaintiff in this case. I have no problem with this sort of thing. But the student dropped out, so it was just Abby. Just Abby. One other point worth mentioning. By the time Fisher 2 was decided, Abby had graduated. What was her injury? Her security deposit.
What about in the last case? Would it have been the same thing? What did they want at that point? I mean, surely they
he wanted admission to graduate school. See, Abby had already graduated from LSU by this point, so she had an undergraduate degree. Bakke hadn't actually been admitted yet to any medical school, so he still had a valid injury. There was another case, I always misspell the name. It's called DeFunis versus Odegaard. Yeah, I never spelled the name right. DeFunis versus Odegaard was another affirmative action case from '74. And the court basically said that because the guy had already graduated, the case was now moot, right? In the 4 years it took to wind up to the Supreme Court, the guy had graduated already. So Abby had graduated, and there was actually discussion of whether they could just moot the case by refunding her application fee, her security deposit. And the school said, no, we want a decision on the merits. So now these cases are actually brought on behalf of classes, these groups that are associated with many students. But Abby did not get her graduate. I don't think she ever got her refund. Maybe she did. I don't think she did. It's very hard to get a case to the Supreme Court. There are all these sorts of procedural barriers that prevent you from actually getting upstairs. I've been stymied many a time, but we're trying hard. All right, Audrey, walk me through the opinion in Fisher 1, please.
They basically first said that the college can consider race a factor in admissions, but only if, I guess.
Well, how is UT? I'm sorry. Let's start a little bit more simple. The facts. How is UT using race?
They were using it through the Grutter v.
Bollinger.
Bollinger.
He's now the president of Columbia University, Lee Bollinger.
And they basically said all the students who weren't admitted through the top 10%, they could seek admission through the other way. The university's, what is it called?
Personal achievement.
Yeah, PAI.
Okay, very good. Thank you, Audrey. The lower court in Fisher, the Fifth Circuit, ruled against her. And they said that this policy was narrowly tailored and that there was compelling state interest. The Supreme Court reversed. And they ruled for Fisher, but they didn't go ahead and say that the UT policy was unconstitutional. They ruled instead that the university was given too much deference, that the court should not give deference to how the university uses affirmative action. Right? In other words, the court has to carefully scrutinize whether, in fact, the use of race is narrow, right? Whether, in fact, using race in a very narrow fashion. And the Supreme Court ruled that the Fifth Circuit did not, in fact, scrutinize carefully. Okay? Right. The university had the burden to demonstrate that every applicant is evaluated as an individual and not in a way that makes the applicant's race the defining feature of his or her application. Okay? Everyone with me? Yeah, go ahead, Tyler.
So the Fifth Circuit's opinion, I mean, it looks like they absolutely did use a strict scrutiny basis, and both once it was their initial assessment and then once it was remanded. I mean, they're almost identical in their application of Grutter.
Yep.
I don't understand what could have been more narrow in the initial Fifth Circuit decision for the Supreme Court to say that they applied the right level of scrutiny.
So you're saying that the UT policy was indistinguishable from the Grutter policy from Michigan?
I'm saying that if that's the precedent, they applied the precedent, and it was narrowly tailored based on what the court had previously said.
Okay, so let me give you this one. What was going on then in Fisher 1? Why didn't the Supreme Court simply just say that we are changing our standard in Grutter?
In 13?
Yeah. It's my second year teaching, I think.
This is when I went to college in freshman year.
2013?
Mm-hmm. I remember the top 10% thing.
Let me give you some inside baseball. And this isn't the casebook of this little excerpt, but Justice Kennedy was in a dissent in Grutter. Right? O'Connor was gone. Her replacement, Alito, did not agree with Grutter. There were no longer 5 votes to uphold Grutter. According to at least one account, Justice Kennedy was originally willing to not overrule Grutter, but perhaps narrow it, and ruled that even in light of Grutter, the UT policy was not permissible, that it was distinguishable from the Michigan policy. Maybe it was, maybe it wasn't, I'm not entirely sure. According to the reports that Justice Sotomayor, with this very sharp dissent, which accuses the majority of ignoring racial prejudice, And as the story goes, it persuaded Justice Kennedy to withdraw his majority opinion. And as a result, Sotomayor joined the sort of middle-of-the-road opinion, which was hoping to punt the issue. Let the lower court maybe strike down the UT policy, then deny review. In other words, don't set policy nationwide, limit it. Right? It was desperation, right? Just do something not to decide a national standard now. Ginsburg, Schroeder dissent saying, what the hell's wrong with you, right? This is perfectly fine. What are you doing? She said, this is consistent with Grutter, right? Sotomayor, who I think would agree with Ginsburg, bit her tongue, withdrew her dissent, and the vote was 7-1, right? Hoping that someone else will deal with this problem. Only Justice Thomas dissented, and Fisher won. He said, overrule Grutter. Affirmative action is not a compelling interest. And he argued at some length that the segregationists in Brown are no different than the academics in UT, right? I remember he was like, oh my God, UT, what is this? Like, he went line by line explaining how the segregationists in Topeka, Kansas were using the exact same framework as the academics in Austin. Okay. After Fisher won, it was sent back to the Fifth Circuit. Surprise, surprise, the same three-judge panel issued basically the same opinion. I think Tyler alluded to this a minute ago. They said the same thing. It's like, okay, thank you, Supreme Court. We're going to do the same damn thing before. And the case comes back up in 2016. Now, at the time, Kagan was recused. There were only 8 justices. As a result, if the court split 4-4, there would only be what's called an affirmance by an equal divided majority. Right? When the Supreme Court splits 4-4, they simply affirm by an equally divided majority. What does that mean? No opinion. Right? When there's a 4-4 split, there's no opinion. And there's no precedent set. It merely affirms the lower court judgment and nothing else. Right? These are the ones we hate because you don't know why they split 4-4. The court does this maybe once or twice a year when there's someone recused. The case is argued with 8 members. I remember listening to this oral argument. I wasn't there, but I listened to the recording. And Scalia was lit. I mean, he was Scalia was very eager and very active, and it was really clear that there were 4 votes. Right? There was Scalia, Roberts, Alito, and Thomas. That there were 4 votes to say that the UT policy is unconstitutional, and that there were 3 votes to rule that UT policy was valid. So, of course, it fell to Justice Kennedy. Had Justice Kennedy joined the conservatives, Sotomayor be damned, he could have ruled that Grutter's limited. But then something else happened, right? Justice Kennedy passed away suddenly in February of 2016. It was February 13th. It was right on Valentine's Day. It was a rough month. His vote never was released, right? Even if a justice casts a vote and dies, they don't release his vote. They take a second vote. So we don't know how he voted. I know how he voted, right? But we don't know how he voted. And it's possible that someone even had a majority opinion, which was then abandoned. So as a result, it was probably a 5-3 reverse the Fifth Circuit, right? What could have been a 5, I'm sorry, well, blah, I said it wrong, my math is wrong. So what would have been a 4-4 affirmance without an opinion became a 4-3 decision to affirm. The Fifth Circuit opinion was affirmed by only 4-vote majority. Query, what's the value of a 4-3 opinion, right? Is that even a majority opinion? I don't think it is, but people disagree with me on this one, right? A 4-vote majority, I don't think is a majority at all. I don't know what presidential weight it's entitled to. And guess what? Kennedy's gone. He's not on the court anymore. So how much weight would the court even give Fisher to going forward? I think we'll find out in the Harvard case and the North Carolina case. But I don't think that Fisher 2 will be the final word in affirmative action. Justice Ginsburg had some sort of comment saying that, I think we're done here, right? I think this is going to be it. She said that when she said Hillary Clinton was going to win, and Hillary didn't win. And instead of Merrick Garland, we now have Neil Gorsuch, and now we have Brett Kavanaugh instead of Tony Kennedy. So I think your prediction was a little bit premature. I'm skeptical that when the next affirmative action case comes to the court that the policy prevails. I'm skeptical. Okay? So any questions on the majority in Fisher number 2? We have a dissent from Justice Thomas, who again argues that we have to overrule Grutter. He's sort of a broken record on this point. We should overrule Grutter, and that the majority opinion cannot be reconciled with strict scrutiny. Right? We should not be using race in this fashion. Justice Alito joked, something strange happened since our first opinion in Fisher. Right? What happened here? And Alito had this sort of barb. He says, I hope this change is attributable to a one-off, that is Scalia dying. But the policy survived to live another day. And to this day, UT has a policy, but not for long. The plaintiffs in the UT case, not Abby Fisher, but the same people paying for it, challenged it again in state court. And they're arguing that the UT policy violates the Texas state constitution. And that is working its way through the state courts. And we very likely may see a Texas Supreme Court decision declaring that the UT policy is unconstitutional. So this ain't over. This issue seems never to ever go away. I don't think it ever will. I think it's such a divisive issue. Abortion, affirmative action, a few other questions, no matter what happens, I don't think we'll get a settlement on. Even gay marriage, I think there's more or less been a settlement on for the most part, but not affirmative action, not abortion. I don't see it happening. Okay. Questions on Fisher 2? All right. Let me give you a little bit of a brief overview on the scrutiny, which will help bridge the gap for tomorrow. Let's see where I have it. Okay. All right. So let's walk through this one step at a time. All right, we have an equal protection clause as a general matter, 3 tiers or levels. And I often ask this question to start, right? What's the driving age in Texas? Was it 16? Okay, when I was growing up in New York, it was actually 17. And I believe now it might have been actually raised to 18, right? So I think to get a permit, it was 17 to get your license, 18, but maybe I'm be off by a year. But whatever. In some states, the driving age is 16. Right? In other states, it's 17. In other states, it's 18. Right? So is it unconstitutional for New York to deny a driver's license to a 17-year-old? Okay. So what's the argument? Why does Texas have a 16 driving age, and why is New York 17 or 18? It could be based on a couple of factors, right? Maybe there's more public transportation available in New York. Just hold on 1 second. 1 second. This is funny. Okay. So why is age different, right? Well, maybe you can say there's more public transportation in one state. Maybe you can say that minors are dangerous to drive, and we want to have safer roads. But generally, the government has more discretion when they classify people based on their age. Why? Because everyone eventually grows up, right? Even if you're 16 today, next year you'll be 17, and next year you'll be 18, right? We all grow up. And the government generally has a good reason why they treat people differently based on their age. We call age a non-suspect classification, right? A non-suspect classification. What does that mean? It's not suspicious. We don't suspect that people are using age to harm people. As a result, we apply what's called rational basis scrutiny or rational basis review. And the test for rational basis review balances the means and the ends. And that's what the fit is. So we ask whether the government policy, in this case the age classification, the means, is it rationally related to serve a legitimate governmental interest? Those are the ends. Legitimate governmental interest is not very significant, right? Highway safety is legitimate. Promoting public transportation is legitimate. It doesn't have to be that important. So with a rational basis review, it's very deferential. So long as they have some legitimate interest and there's basically a rational or reasonable fit, it's valid. Is making the driving age 18 to keep roads safer rational? Yeah, makes sense. Do they have to provide statistics showing that 17-year-olds are reckless or that 16-year-olds will get into accidents? No. With a rational basis review, right? With a rational basis review, all they need to show is that there's some sort of rational relationship. And the burden is on the challenger, right, the plaintiff, to show that the laws are rational. This is the basis of the presumption of constitutionality, which we've discussed before. This is Caroline Products, right? That the plaintiff has the burden to show the law is irrational. Does that make sense? Right? So when you have a non-suspect classification like age, or maybe how much money you have, right? The government can do just about whatever they want. They can get away with stuff because it's not that important. But then we have sex, which is your reading for tomorrow. Sex is what's called a quasi-suspect classification, right? Quasi means like kind of, almost, a little bit. And these quasi-suspect classifications are reviewed with intermediate scrutiny. Right? The review with intermediate scrutiny. And intermediate scrutiny is a little bit tougher to satisfy. Here's the test. The government policy is substantially related to serve an important governmental interest. Right? The government policy is substantially related to serve an important governmental interest. So, like, just compare and contrast, right? Here, the interest only has to be legitimate. Here, it has to be important, right? So on a scale, you have legitimate, and then something bigger than legitimate is important. So maybe highway safety by itself is not enough. Maybe something even greater than that. Also, the tight has to be fitter. It's not enough to show a rational relationship. You have to show substantial relationship. Right? Substantial relationship. In other words, it has to be even closer, right? You need to really show that this is necessary, that separating people based on their sex is really important. You have to really have a good reason to do it. Critically, when you have when you have intermediate scrutiny, the burden shifts. It's the government that has to show its law is justified, not the challenger, the government, right? That's when the key moves. In constitutional litigation, when you have the burden, you're probably going to lose, right? When you have the burden, you're probably going to lose. However, when you have the government with the burden, you just might win. Everyone with me? All right, the final tier is what's called a suspect classification, right? Which is basically race, nationality, religion, a couple of them. When the government classifies people on the basis of race, the race classification is suspect, suspicious. And then you apply what's called strict scrutiny. This is the hardest test of all to satisfy. The governmental policy has to be narrowly tailored to serve a compelling governmental interest. So look what happens, right? You have a legitimate interest in the first one. You have an important interest in the second one. And the third one has to be compelling, right? It has to be really important. This is Justice Thomas's point. He argues even if affirmative action benefits are legitimate or important, they're not compelling. They're not the highest order. But more importantly, you need to show even the tightest fit. And the way I think of this is like with a suit, right? You can go to, Sears. Sears doesn't exist anymore. You can go to Walmart and buy a suit off the rack. It will not fit you well, right? It'll be hanging off you. It'll be kind of drooping off your arms. It's not well tailored. You go to a tailor in Italy, right? Custom tailor. They'll make you a suit that fits you perfectly. It's narrowly tailored. If you want to use race, you can't buy the off-the-rack thing at Kmart, right? You have to buy a narrowly tailored suit. A policy that uses race no more than necessary. You don't use a stitch more fabric than needed. You only lose the minimum amount of fabric necessary, right? You don't have this hanging, droopy clothes. You use as little fabric as possible, as little use of race as possible. That will pass muster. Which is why the question in the Michigan case and in UT was, how much are they using race? To what extent are they actually using it? Are they using race too much? Well, the undergraduate did. It was the deciding factor. The law school used just the right amount. Think like Goldilocks. Not too hot, not too cold, just right. Okay, and there's the video for the gender scrutiny, which is your video for tomorrow, has this helpful graphic, which is much prettier than my lecture notes. But you can walk through this, which explains the 3 tiers with classifications. By the way, these sorts of tests, these are the general statements, but the court often uses different language. These are not in stone, but these are the general tests which I use to help explain them. Okay. All right, questions?
Is sex the term we're going with?
You know, that's such a good question. It's such a good question. Justice Ginsburg tells a story often that one of her secretaries, I think, would often say, you know, you should stop using the word sex, you should use the word gender, because the word sex is like yucky, right? So Ginsburg changed it from sex discrimination to gender. But in modern discussion, we've gone back to sex, because sex has a bigger thing, because gender perhaps is not what it meant at some time. In other words, gender suggests tied to anatomy, whereas gender identity might not be. So the statutes use the word sex, but there's flux on what the correct term is, and I don't. Let me ask you this one. Usually in abortion cases, the court refers to the person who's pregnant as the mother. And that never fazed me. You know, health of the mother, life of the mother exceptions. In a recent dissent, Justice Ginsburg criticized Thomas for saying a person seeking an abortion is not a mother. CNN. Yeah. Hey, I'll call you back in 5 minutes and we'll done with the class, okay? Okay, thanks. It's okay, I'm almost done. All right? It's okay. No, it's okay, we're almost done. Right? So what's the better term? I have my priorities, you. I was almost done anyway. Right, so what's the term then? Mother or person seeking an abortion? I don't know. Randy and I debated this. Well, the terminology is hard because the movements of the day use different languages, and words that were forever available weren't. I mean, even if you look at Supreme Court decisions, until the 70s, the word Negro was used in opinions. And that was considered actually favorable to the other word, which is far worse. But that's fallen out. Now the phrase people of color is now used in fairly wide acclaim, and for some time that was considered pejorative. So the terminology sort of fluctuates. So I don't have an answer to your question.
Is national origin, that's up there with race?
Yes, strict scrutiny, and religion as well. Although religion cases are often, I think, closer to equal protection rather than, there's more of a free exercise than anything else.
Even if it is a presumption of liberty, if in and of itself it's constitutionally prohibited, it's constitutional. I'm thinking, what if President Obama was born in Kenya?
Well, then he's not. That's not an equal protection issue. That's an Article 2 issue. That he would not be a natural-born citizen.
Right, but what's the government's interest? Can one challenge that?
Well, that's an interest stated right in the Constitution. You wouldn't need it. It's enumerated. Right. This only comes in when the government classifies you on the basis of race.
Protection.
Yeah. Yeah. All right. Any other questions? I'm going to call her back now. All right. I'll see you guys tomorrow.